Hello guys, and welcome to another episode of my lecture. On today's lecture, we will be talking about the Australian position on the indoor management rule. Do not forget the non-ostensible conduct as well as the ostensible conduct that I taught in my last lecture, and let us see how it's applicable in this case. Starting with our Australian case of NORTHSIDE Development Property Limited versus Registrar General. The fact of the case is that N in this case means NORTHSIDE Development Properties. I just didn't want to say it every time, so I will just say N. N had 3 directors, and the son of one of them took over as the company secretary. N mortgaged a certain piece of land. Now that land belonged to N here being NORTHSIDE Development Property Limited, to secure a loan of $1.4 million for the company controlled by Robert Sturgis. Robert Sturgis is one of the directors. Now, the loan which N got by mortgaging its property was for a company which belonged to Robert Sturgis, which was one of the directors. When the loan was not paid, Barclays Bank sold land to a purchaser by auction who registered the land in good faith. Barclays Bank was the bank who gave the loan to N. Now N, after losing its land, sued to obtain damages from the Registrar General of the New South Wales. Mortgages had been executed without knowledge of all the directors and without authority from N. Do you understand? The company had not authorized such mortgage, and even other directors, they were 3. The 2 other directors had no knowledge of such. The company's seal was on the mortgaged document attached by Robert Sturgis and his son, that's the purported company secretary, without authority of the company. The Articles of Association required either 2 directors present when affixing the seal, or a director and a company secretary. Therefore, we now know what the ostensible conduct is. For third parties, their ostensible conduct, the things that they must see as authorized by the article, is that for the company seal to be affixed, then it must be done in the presence of a director and a secretary, or in the presence of 2 directors. In this case, we have Robert Sturgis, who was one of the directors, and his son, who was the company secretary. Therefore, they've complied with the ostensible conduct. Do you understand? Now, the mortgage secured a loan to companies which were owned by Sturgis. NORTHSIDE, that is N, had no interest in either of the companies. The case raised issue of extent to which third parties like Barclays Bank is obliged to go behind the seal and signature of office of company it contracts with. Do you understand? Now, we are saying that the third party in this case, being Barclays Bank, they were supposed to know that this particular mortgage is not executed on behalf of N, who has the land. It is executed on behalf of Robert Sturgis' company, and N does not have any interest in Robert Sturgis' company. Do you understand? Therefore, there should be some suspicion there that something is wrong. Do you understand what I'm saying? Now, the issue was whether Barclays Bank should have been put on inquiry, or whether it could rely on the common seal as evidence of NORTHSIDE agreement. Relying on the common seal is the principle of regularity. But the question is, would the principle of regularity still fall true where there are suspicious circumstances that can put third party on inquiry? Now, the judgment of the court, the High Court of Australia, examined the rule in Tokant's case, holding that the rule is displaced where there are circumstances putting on inquiry the party seeking to rely on the rule. Here, the fact that the instrument of mortgage was given to Barclays Bank not for the purpose of N business. The land belonged to N, but the mortgage, the loan, was not going to N. I believe that should have put the bank on inquiry that something is wrong. The court is saying that the fact that the instrument of mortgage was given to Barclays Bank not for the purpose of end business but to secure debt of Sturgis Company was enough to put Barclays Bank on inquiry. Another exception is in the cases of forgery, but we are not going to talk about that now. Dawson J said that the rule in Royal British Bank versus Stockand doesn't apply here on two grounds. The first one is that there are special circumstances sufficient to place a person dealing with the company upon inquiry, and secondly, a document sealed, signed on behalf of the company is forgery. Now, in relation to the first deception, Marcin J noted that it wasn't possible to provide specific guidelines as to circumstances in which a person dealing with a company will be put on inquiry, but relevant matters include powers of the company, nature of the business, apparent relationship of transaction to business, and actual or apparent authorization on company's behalf. Guadran J stated that a company may answer an assertion that it has bound itself to a transaction embodied in an instrument to which a seal is affixed by establishing that the seal was fraudulently affixed. Transaction wasn't entered on behalf of the company but with intent to defraud. Such answer, however, won't avail a company if such company is otherwise stopped from denying the transaction was entered on behalf of the company. This case falls under one of the exceptions to this indoor management rule, but it's very important for us to note is the principle of special circumstance, where there has been a special circumstance, so much so to put the third party on inquiry, meaning that a reasonable person would look at this thing and say, there is something wrong. Imagine that the director of a company is coming to get loan from your bank, and then the director is using the land of a particular company to get loan for another company, whereas the first company does not have interest in the second company. The company whose land they are using doesn't have interest in the company who is receiving the loan. I mean, there is something wrong. That is the special circumstance. The second one is forgery, where the company's seal has been affixed with the intent to defraud. Do you understand? Now, we are going to go to Nigerian cases to better understand this principle, also using the ostensible conduct as well as the non-ostensible conduct. See you in my next class.